Good afternoon. Welcome to our webinar. Today's topic, childcare and contact, or sometimes referred to as custody and access. The new term since the Children's Act came into operation, we're using the term care and contact. So that's the way we go about that. Many people still refer or use the term access and custody. And of course, there's the issue of concerning guardianship as well, the legal rights or the legal responsibilities regarding a minor child. Nonetheless, let's deal with today's topic, childcare and contact. Generally, I'll be dealing with the issue concerning various aspects of child custody, child maintenance, guardianship, relocation, and so on. Nonetheless, we have a few questions which people posed previously in the last few days. I have in a I have changed the questions a bit to deal with it more in a more legal fashion. Sometimes when people pose these questions, they use shorthand, they type it from their phones, and sometimes you do not know exactly what the gist of the question is. But nonetheless, I tried my best to not to lose too much of what the people have typed when they send these questions to us, and hopefully I'll be able to do justice to the specific question. So I have 5 questions on the whiteboard. This must be number 5 as well. I have 5 questions on the whiteboard and I'll be dealing with those. If you have any live questions, if you are watching this video live, please make use of the Advocate Muhammad Abduroaf Facebook page. I'll be keeping an eye on that specific page, and if you do pose a question on that specific page, I will deal with it. I am seeing a question now live as well, so thank you very much for that. Anyone else have live questions, feel free to pose it. But let me first get through this question list of the people who posed these questions previously. The first question is, the mother is suffering from depression and I think she is bipolar. What can I do if I want to have custody of my child? I see him every weekend and he's 4 years old. Okay, so reading in between the lines, it's a father posing this question. He believes the minor child he believes that the child is not being properly cared for by the mother because of the mother suffering of depression, and he potentially believes the mother is bipolar as well. Now he wants to have custody over the minor child. So the question you'll pose to me, or someone will pose to me, is it by default if a caregiver, a primary caregiver, suffers from depression and is bipolar, does that make that specific parent unable or inadequate of caring for a minor child? And of course the answer is by default not yes. I cannot say yes it does, because with depression, with bipolar, there is medication for that, and if it's well treated, you should not have a problem. You can continue with life. And also the specific patient or the specific parent may be able to handle the depression and the bipolar very well and care for the minor child in a very good manner. And the flip side, which we're not dealing here with and which needs to be posed, is can the father in the specific example or question, can he care for the minor child just as well or better than the mother can? And the question is, what problems does he have? Does he have any challenges? He might not have bipolar, he might not be suffering from depression, but he might have other conditions or circumstances as well. So by default, you do not deal with a matter like this by stipulating, firstly, okay, the mother has depression, she suffers from bipolar, automatically the child should now go to the other parent, and we presume, without any information before us, that the child would be cared for better by the other parent, or that the other parent can care for the child just as well as the mother can. There are various aspects to look at. Firstly, the age of the child. The specific example, the child is 4 years old, so quite young. And, does depression and does bipolar affect the caring capabilities of a minor child of 4 years old? But I'm looking at that from that specific angle. The other sphere we have to look at is the father. Can he care for the minor child? Why is the minor child in the first place not with him? That's very important. And the specific father does not mention that he is capable. He's not providing us with that information to substantiate that he can care for the minor child better than the minor child is being cared for by the mother, despite the depression and despite the bipolar. Or I'm not obtaining information from the father explaining to me the level of the depression. How does it negatively affect a caring of the minor child and the bipolar? Does it affect the minor child, or is the minor child very happy? Because a 4-year-old child is supposed to be happy, enjoying life, going through those milestones, learning how to run, to talk well, to play, to possibly spell the name and so on. So that's what the child of 4 years old has to do, not necessarily having a parent assisting him with assignments, homework, etc., and X, Y, and Z. So nonetheless, if the father in this specific question believes that he can care for the minor child better than the mother because of other reasons as well, for example, he can, you know, stay up at night to care for the minor child should the minor child be ill. His structure, his work program allows him to be a caregiver of a 4-year-old child, and he has the temperament, the patience, and the insight on knowing how to look after a 4-year-old child. Then wonderful, then maybe the playing field becomes equal on that basis, but not by reason of the mother being suffering from bipolar or depression. So I hope I answered that specific question as objectively and as properly as possible. Nonetheless, let's deal with question number 2. I have a job offer to work in Dubai. I work as a teacher currently in Gauteng. My child is 10 years old and I want to take her with me. The father's name is on the birth certificate and he does not agree with my daughter going with me. What can I do? He pays maintenance. Okay, a scenario which comes about quite often these days, the issue of relocation. Here we have a primary caregiver, a mother caring for the minor child. The father pays maintenance, and I'm certain he has contact often with a minor child, maybe in terms of a parenting plan or some type of agreement the parties may have. But that's not an issue. Things are going well. Now the mother wants to relocate to a foreign country, and in this case, Dubai, to teach. And she would like to take a child with her of 10 years old. Now, what differentiates international relocation matters with the normal run-of-the-mill care and contact matters are that generally the child in the normal circumstances would be living in the same suburb, the same province, both with the parents. And therefore the only issue is how much contact should the minor child have with the other parent every second weekend, half school holidays, and so on. Here we're having a scenario where the minor child will relocate with the primary caregiver to a different country, to a foreign country, leaving the parent who remains in South Africa with a total different level of contact with the minor child. He might see the minor child once every 2 years physically. Yes, we know we have Skype, we have Zoom, we have FaceTime, and so on. But however, that aspect of picking the minor child up from school, taking the minor child to school, extramural activities, spending weekends with the minor child, going to the park, going to the pools, going to the beach, and so on, will not happen anymore. So here we're dealing with an issue concerning international relocation, which is quite complicated in the sense of the court must first determine whether or not it would be in the minor child's best interest to relocate with a parent in the first place. So we're not dealing with care and contact issues at that specific time. Then the second leg would be what type of care and contact arrangement should be in place for the specific parents should the minor child relocate with a primary caregiver. But those things are not that hard to work out because, contact would usually be unlimited at reasonable times. And reasonable times can be a bit complicated. Okay, Dubai might not be much of a problem, but let's say the minor child relocates to the United States, whereby a good time for the minor child might be in the afternoon between maybe 5 or 4 and 7 or 8 o'clock. However, that might be a total different time zone in South Africa. And that could cause certain type of complications with the parents having contact. Either the father would have to wake up extremely early, or he'll have to be awake extremely late at night in order for him to have contact. Nonetheless, under these circumstances, seeing that the father is involved in the minor child's life, his name's on the birth certificate, the Department of Home Affairs would obviously require the father's consent for the relocation. They would require that. And at the same time, for the mother to apply for a passport, the Department of Home Affairs would require the father's consent as well. In a matter like this, the mother would have to convince and the mother is the one asking for the advice. So we are answering this question on behalf of the mother, putting on my advocate's cap for the mother. The mother would have to convince the court that she set up a situation in Dubai that will be conducive for the minor child's well-being, in the sense of she's looking after the minor child while in South Africa during the week, taking him to school, feeding him, caring for him, doing his assisting him with his assignments, and so on. But should the minor child relocate with her to Dubai, the minor child would be cared for just as well as he was, or as the minor child has been cared for in South Africa. That's the one aspect we're focusing on, the minor child. The minor child will be looked after. Secondly, the issue of relocation per se. Why does the mother want to relocate? Here is for work purposes. Does it make sense for the mother to relocate to Dubai if she'll be earning the same amount of money? This is in my example, my question I'm asking you. She'll be earning the same amount of money in Dubai as she's earning in South Africa, and there's no logical reason for her to go to Dubai other than maybe experiencing the world. But that is also a valid reason for someone to relocate, to experience the world and to, see different places. So the court would have to look at that as well. Now, after we have concluded that it will be in the minor child's best interest because the minor child will be going with a caregiver, requires to go overseas to better employment or whatever the case may be, the parent remaining in South Africa would have an argument. The parent remaining in South Africa will stipulate, no, the child should not relocate. Firstly, school, change of school, friends, family, contact with the caregiver as well. The father would not have contact with the minor child as often as he has, maybe every second year. And with COVID-19 being so difficult, we do not know what will happen in the future. He might see the minor child, after a very long time again, physically. So he would argue that. And what would his argument be? If he's very good, he would not necessarily argue on the basis that the mother cannot go overseas. He would argue that if the mother wants to go overseas, she can go overseas and she can do what she wants to do. But the minor child should not go with the mother. And with saying that, he would have to argue and present to the court that he can care for the minor child adequately in South Africa and the mother can go away. So that's a debate that has to be determined. And if you look at that specific scenario, that specific situation whereby he came for the minor child, we have to say, is it best for the minor child to be cared for by the father who has no experience? Let's say those are the facts. He has no experience, the minor child does not know him so well. He usually only sees the minor child once every second week. He remarried, he has some step kids as well. The house is very small. Whatever the case may be, I'm just trying to be difficult here, making his case a bit hard. But you will have to convince the court, if you consider everything, the child will be living in his environment, but at the same time, the child will be living in South Africa, remaining in his current school, friends, family, and so on. As opposed to going to Dubai, living with a mother, total new school, but the mother as primary caregiver will be looking after him. So those are the debates that will have to take place. So if you are following my argument, you need to convince the court, either father or mother, but here in our case the mother, that it will be best for the minor child, and the minor child cannot remain in South Africa because you are not there, number one, and secondly, the parent living in South Africa cannot care for him or her. So I hope I dealt with that specific question, and if I have not, you're welcome to comment a bit further. The third question, and the person that posed a question on Facebook, I shall deal with your question after question number 5, and then we can unpack it further. What do I do if my child does not want to visit his father? Our divorce agreement says he must visit every second weekend. However, my son does not like his new wife and stepbrothers and sisters. He's 17 years old. Must I force him? Okay. Divorce parents, divorce order, stipulating that the child should go to the dad every second weekend. So it's an order of court, complicates matters a bit. The child does not want to go because maybe the father remarried and he does not get so well on with the stepmother and the step siblings and so on. But he's 17 years old, he's an adult soon. In the next few months' time, he'll be an adult. Now, when it comes to kids at this specific age, it becomes a bit hard because a 17-year-old is almost an adult. He'll be an adult in a few weeks' time, a few months' time. And what do? Do you force a child who basically knows what he or she wants and who is maybe in matric or grade 11, whatever the case may be, some of them at that specific age is already a technicon. Do you force a child at that age to go to a parent? Yes, in principle, the child does not necessarily decide what's best for him or her. A child decides the parents decides what is best for the minor child, not the child himself. However, a person has to be very sensitive and smart here. Yes, if you ask me the question, must a child go? The order said yes. My answer is yes, so you must follow the order. But if you have a situation whereby the child does not want to go, and the parent who would be exercising contact, in this specific case, the father is adamant he wants to have contact to the minor child, and there's a court order in place stipulating that, I strongly believe under those circumstances, you need to take this matter back to the court. The court needs to resolve this issue as soon as possible, because you do not want to force a child of 17 years old to have contact with another parent if the child does not want to, without trying to mitigate the matter. And the way to mitigate the matter would be to take this matter to court, because a child of 17 years old is very vocal, and you do not want to traumatize this child. In taking the matter to court, we would of course want a social worker, a psychologist, somebody to be on board to assist in assessing this matter. I mean, remember, the parents, they are not psychologists. They do not necessarily know what is best for the minor child objectively, because they are all acting subjectively. They have issues with the other parent and so on, or sometimes the minor child plays them as well. That happens often. But be that as it may, the mother in this specific scenario needs to take this matter urgently to court and have the court reassess this matter as soon as possible. But until then, unfortunately, depending on how far she acts, the minor child would have to go to the father unless she goes to court urgently, and the court can relook this matter sooner than later. And because the minor child is 17 years old, there are a lot of variables who play. Number one could be the minor child might turn 18 years old in a month's time. And now you have to go to court, urgent litigation to be heard in a week's time, where that order will only be applicable for the next 3 weeks' time. I think parents will be silly to litigate a matter for 17-year-old on that specific basis, spending so many thousands of rands on legal fees just for the father to have contact with a minor child for the next 3 weeks. And the child will become an adult after that. Okay, so in summary, my answer would be basically focus on what's best for the minor child. However, because there is a court order and the parties cannot come to an agreement, urgently approach the court and have the court reassess the matter and determine what is best for the minor child. That was question number 3. Let's deal with question number 4. I am in the process of getting divorced. I was told that I can ask for maintenance from the divorce court. Is it possible, or must I go to the maintenance court? The answer is yes, it is possible in a pending divorce matter to approach the divorce court itself for a order regarding child maintenance, care and contact. That's possible as well, and also a contribution towards legal cost. So that is possible. So in the High Court, for example, it will be a Rule 43 application. Usually what the parties do is you first issue the divorce summons, you serve it upon the other side, and soon thereafter you make an application in terms of Rule 43, basically stipulating I require maintenance for myself and for the minor children, X amount of money. I would like to have these interim contact arrangements in place. The minor children should remain with me if I'm the mother, and the father can have contact every second weekend, whatever the case may be. And at the same time, we like the father, if he is earning all the money or he has assets and so on, to contribute towards the legal costs. So that's how it works. So it's possible. It can also be done before the divorce and also with the divorce summons being issued as well. So that is possible. Question number 5, the last question before we deal with the live question. The father of my child is missing. He does not pay maintenance nor visit the child. The last time we had contact was in 2000. That's quite some time ago. I think that should be wrong. It is 2010. My apologies for that. 2000, the child would be an adult by now. I want to get a passport for my child. Home Affairs says I need a court order. How do I get it? Okay, so let's deal with this matter from the foundation. Minor child, the father and the mother are guardians over the minor child. So they both have parental rights over the minor child. I would presume these parties, maybe the child's name is on the birth certificate. I would presume the father is involved in the child, was involved in the child's life at that specific time. But now when the mother went to the Department of Home Affairs and showed him the birth certificate, they said, oh, okay, I see, there is a father, we require his consent. The mother might say the father was not involved in the child's life since 2010. They'll say, how do we know that? You could be lying, whatever the case may be. And they require the father's consent, and they'll tell you, if you cannot get the father's consent, you need to come back to us with a court order. So that's what the mother needs to do. We make those type of applications quite often, whereby parents have challenges in, number one, maybe living or assisting the child in his life, for example, enrolling to schools, extramural activities, consent. For example, let's say the child has to go for an excursion and they require the guardian's consent, or the minor child would like to go overseas on some trip because the child is very talented and the guardian is not available and hard to be found. So nonetheless, under these circumstances, I would advise the specific person to urgently approach the court and ask the court for an order that the court appoint him or her as the sole guardian of the minor child, and in this case, a mother. So basically, you approach the court, you tell the court, these are the problems I have for the last 10 years. Father is missing, he never paid any maintenance. I had problems with enrolling the minor child to primary school, to high school. I'm still having problems. I cannot get a passport for the minor child. All these problems, but the father is nowhere to be found. The High Court will assess this matter, and the court could possibly make an order that, Mom, we believe you, we accept what you are stipulating. Here is an order stipulating that you have sole guardianship rights over the minor child. Go to the Department of Home Affairs, show this order to them, and they would not ask for the father's consent. So that is possible. The court would obviously make an order like that if the court believes it would be in a minor child's best interest, but generally, if the father abandons the minor child and the family and so on, the court would make such an order. Okay, I hope that answers question number 5. If you have not and you are watching this video and you have posed a question to us, this usually happens this weekend, you're welcome to comment. We have now the live question. Let us deal with that. Okay, here's a live question. Hi, I'm going to the maintenance court tomorrow. I saw my ex and son at the restaurant and went to say hi to my son. He quickly called his lawyer and said it's harassment. Can he do this? I'm in Johannesburg from Durban and hardly get to see my son, but he says it's his time with the child. All I did was say hello and hug my son, etc. He was excited to see me. I do not necessarily per se, I wasn't there, so I do not know what the other dynamics are, but on the facts mentioned over here, if you were, for whatever reason, coincident at the shopping mall and you see your son, normal people, they greet each other and hug each other. So you would obviously have to prove to the court that it is harassment. What would be harassment would be that you stalked him, you came out of nowhere, you knew you're following him, and that is why you were there and you planned this from the word go to be there and to see your son and to, of course, communicate with the son and limit, or in some way or another, not frustrating his contact with his son, but also, you'd prefer you not to have been there. But nonetheless, on the facts which I have mentioned, to me, I do not see any form of harassment. If you were there, by the way, and it was a total coincidence, and you in no way frustrated his contact with a minor child. So that should be fine. If I did not deal with the matter properly, please tell me and I will try my best to answer it in a different way. So nonetheless, thank you very much for your time, everybody. That was 5 questions and 1 live question. I think we dealt with it quite well in the last 25 minutes. Thank you very much for watching this video, and I hope to see you online again soon.